Welcome to our discussion titled The Place of African Customary Law in South Africa's Legal System. My name is Philani Ndlovu and I'm presenting this lecture on the 15th of August 2021. This is a special day to me for some reason. Now, coming back to our topic, South Africa is a system, pursues a system of law where we say there is legal pluralism. What we mean by legal pluralism, we mean that law in South Africa is actually derived from a number of systems that dovetail. We have, for instance, the laws emanating from the Roman Dutch traditions, which were brought into South Africa through at the arrival of Jan van Riebeeck and the people that came to settle in South Africa from Europe, having also some Roman background in it. And then when the Cape of Good Hope was taken over by the British in 1806, English law, principles of English law were then grafted into the system of law in South Africa. We have got also people that live their lives on the basis of religious law. For instance, we are talking here about Islamic law as it applies to Muslim communities that are resident in South Africa. And then we have got also people of Indian background who also have their own customs and traditions which shape their lives while they are here in South Africa as citizens of the country. And then we have the bulk of the South African black community, that is the indigenous people of South Africa, whose lives are regulated in terms of indigenous laws. That is what we call the African Customary Law. So when you look at the law of South Africa in terms of legal pluralism, you find that we have Western law principles which incorporate Roman Dutch principles, English law principles, and then we have got Islamic law, then we have got Hindu and other principles or other customs of Indian origin. Then we have African customary law, which, as I have said, regulates the bulk of the larger population of the people, particularly the indigenous people. We are talking here about the Nguni peoples, people that fall within the Nguni ethnic group, such as the Zulu, the Xhosa, the Swati, and the Ndebele. And then we have those of Sotho again, classification where you would have Southern Sotho, you will have your Spedi, and you will have your Swana as well. Then we also have people that live according to Venda customs, according to Tsonga customs, according to the Lovetu customs. The list is endless. There are so many cultural groups with diverse interests here in South Africa. So when we talk about African customary law, that is precisely what we are looking at. In our discussion, this is our outline. The first slide, the next slide that we are going to look at discusses what African customary law is, answering the question, what is African customary law? Then the next one is the history of African customary law in South Africa. After that, we will look at how African customary law fits into the South African legal system. And then we will look at the Constitution of South Africa and the African customary law, how they dovetail, how they relate to one another. And then we'll look at the nature of African customary law, as well as the application of customary law in post-apartheid South Africa. And then we'll also go on to look at spheres of life affected by African customary law in the South African context. And then we will go on to look at our concluding remarks. Question: what is African customary law? And we endeavor to answer it in the following way. It is the indigenous laws of the various ethnic groups of Africa before the advent of colonization, which survived. These are the principles which survived the colonial experience, were altered by it, and are still applied by the communities that subscribe to these principles. African customary law applies to indigenous African communities where it is embedded in the deep fabric of the social, economic, and spiritual values of the people. It does not constitute a single body of rules but varies from community to community, evolving in response to the changes that occur in the communities that it regulates. And then it consists of unwritten rules, practices, or principles which enable it to be dynamic rather than static, because it is the living law which tackles issues as they arise without disrupting the fabric of the society or uprooting the subterranean values upon which it rests. So basically we're saying, since this is the law of the land, the original law of the land, that is the African land, these are the principles, the customs of law that were applied before colonization. They continued, therefore, to be applied during colonization for a number of reasons. And then even in post-colonial Africa or post-apartheid Africa, you find that these principles continue to play a very significant role in the lives of the people. For instance, one might ask why these principles continue to apply during the colonial period. You will understand that the British, the French, and the Portuguese had different approaches to the administration of colonized territory. And because South Africa was particularly a colony of Britain, you will find that the British preferred to use or to employ what they called the indirect rule approach, whereby they left the authority in the hands of traditional leaders, that is the kings, the chiefs, and the headmen, so that they could continue to administer territory and apply these indigenous laws to keep order within the African communities. Because the Western principles of law, the Roman Dutch law, that is principles of procedure, criminal law, inheritance, marriage, and other spheres of law could not be applied on Africans at the same time as these other indigenous principles were still prevalent. So in order to take away the burden from the colonial administration and the cost of implementing Western law principles, the colonialists felt that it was appropriate to just assign the indigenous traditional leaders the duties and the authority to administer territory that previously fell under their control. As a result of the continued application of indigenous laws, that is the African customary law, you find that the law has had to evolve. So the pre-colonial customary law is not the same as what was applied during the colonial period. Neither was it the same. Is it the same with what is currently perceived as customary law right now? As I have already highlighted above, we find that it was used by colonialists to administer indigenous populations through the system of indirect rule. It was distorted by colonialists and it was manipulated to meet the needs of the colonial administrators and not the local communities. The story of how Theophilus Shepstone was instrumental in influencing and codifying the Zulu law and bringing in his own perceptions about it, to the extent that Zulu law as we know it today is actually much a product of what Shepstone Theophilus did. Of course, there are still some remnants of the pre-colonial Zulu customs, but to a great extent, the influence of colonialism on this rule was very, very significant. So you find that African customary law was applied subject to the repugnancy principle. Courts did not take judicial notice of its rules, which had to be proven through leading of evidence. Principles were applied with a Western slant, as unknown principles such as primogeniture, a trust system, and other innovative introductions, were grafted into customary law systems, and in a way that they were never known before among the Africans. And then, so you find pre-colonial customary law was different from the colonial and post-colonial versions of African customary law as we know it. Writers like Charnock as well as Terence O. Ranger have spoken significantly about how African customary law was disrupted. Terence Ranger actually has an article entitled the creation of tradition, the invention of tradition in Africa. So our next question is, how does African customary law fit into South Africa's legal system today? Well, it is an integral part of South Africa's legal system, as revealed and as enunciated in the court case of Alex Coe versus Rectorfield Community. We will discuss this a little bit later on. But you find that customary law occupies an equal position to common law or Western systems of law in the Republic of South Africa. It regulates and shapes various spheres of people's private and public lives. It is a law written in the hearts and the minds of those who subscribe to it. People's lives are guided and shaped by it, notwithstanding that it is not written on paper. By saying that it is the law written in the hearts of the people, we are implying that people who live according to customary law actually know and share these principles informally in every gathering. So an African living in a particular community tends to fully understand, at least to a great extent, the principles of customary law as they are practiced or upheld within his or her community. Now, the Constitution of South Africa has actually created space, or rather it recognizes the role and the function of customary law in the post-colonial or post-apartheid system. For instance, Section 15.3 of the Constitution does recognize the value of African customs in, the protection and propagation of family values and other values. Section 31 of the Constitution particularly protects or enshrines the right to enjoy culture, to practice religion, and use one's language, while Section 39 enjoins the courts to develop customary law in such a way as to promote the spirit, purport, and objects of the Bill of Rights, while Section 211 recognizes the institution, status, and the role of traditional leadership according to customary law. And then Section 212 actually enjoins the Parliament, the national legislature, to enact legislation that may provide for a role of traditional leadership as an institution. So you find these are the issues that are, as far as African customary law, the Constitution accommodates it in a very elaborate way. Now let's look at the nature of African customary law. It is living law in that it adjusts in response to changing circumstances. It is flexible rather than rigid. It is accessible to the masses as it does not adhere to strict procedural rules. It is consensus seeking rather than adversarial. It pursues social cohesion, group solidarity, and communalism, and it attaches protection to the family unit and the community instead of individualism. It engenders a win-win for all rather than zero-sum outcomes. Whilst you find that with Western systems, it's all about zero-sum outcomes, winner take all kind of litigation. But we are saying there is a difference in the approach of African customary law, because it actually engenders a win-win for all and tries by all means to avoid zero-sum outcomes. Now, it is gender-based instead of being equality-driven. So we find there are some societies that are matrilineal and others which are patriarchal. Thinking about the matrilineal societies in South Africa, you would be thinking of the Balobedu, whilst the rest, such as the Nguni, tend to be patriarchal. Now you find that African customary law also exhibits tensions with some of the constitutional values. It is in conflict. There is kind of tension when it comes, for instance, to principles of patriarchy versus the right to equality, whether men and women should be perceived as equal and so on. So you find that because women have largely been assigned less dominant roles in African customary law, the principle of equality therefore doesn't sit very well with principles of African customary law, because you find it condones gender-based discrimination in certain spheres of life. For instance, we have practices such as lobola, ukuhlolwa kwezintombi, ukuthwalwa kwezintombi, or the levirate marital unions such as ukungena when a deceased brother, when a brother is deceased, you find that his younger brother or a male family member then inherits his wife. We also have the issue of the surrogate marital unions, where a sister, a younger sister of a deceased sister may actually take over her husband. So you find that these views are these practices are viewed as discriminatory of women, and therefore, some people are calling for the chastisement of African customary law to bring it in line with the principles of the Constitution. Still on the issue of the application of African customary law in post-apartheid South Africa, I have said earlier on that we have the Alex Co versus the Rectorfield community and others case, which was held in 2004. In terms of this case, the court underscored that in fact it dealt with the relationship between African customary law and the rest of the laws, particularly common law. And in paragraph 51, the court underscored the fact that while in the past customary law was seen through the common law, it must now be seen as an integral part of our law. Like all law, it depends for its ultimate force and validity on the Constitution. Its validity must now be determined by reference not to common law but to the Constitution. So the repugnance principle is no longer applicable now to customary law, except that the principles of customary law must always conform with the Constitution. Then there was another important case in 2005, the Bear and others versus Khayelitsha Magistrate and others. That was in 2005, and this case dealt with the principle of primogeniture to determine whether women could actually were eligible to inherit from their deceased parents, as opposed to the primogeniture principle, which held that it was the male, that is the senior or the eldest brother, the eldest male member of the community of the family, who was entitled to inheritance. So another case that dealt with the ability of women to ascend to traditional authority was the Shulubana and others versus Nwamitwa and others case that was heard by the Constitutional Court and heard in 2007 and decided in 2008. So these are some of the very important cases that have dealt with these principles, particularly the tension between African customary law and some of the constitutional values. Now, let's look at some of the spheres of life affected by African customary law in South Africa. It obviously affects marriages. For instance, we have the recognition of Customary Marriages Act. And then there's also the issue of succession and inheritance. We have already spoken about the Bear versus Kaelicha magistrates case, where the court ended up abolishing the primogeniture rule and then subjecting customary inheritance principles to common law principles through the Interstate Succession Act. And that has been heavily criticized by the proponents or those who are very much inclined towards the protection of African customary law. And then it also deals with property rights, and we have spoken about the Bear issue, and also the issue of the rights of women in rural areas, for instance, to have access to land, whether women should not be given access to land and whether they should continue to gain access only through maybe the agency of their brothers or their husbands, taking into account that women have traditionally not always been entitled to acquisition of land rights in their individual capacities, but it has always been assumed that they can gain access to land secondarily through their husbands or through their male relatives. African customary law also deals with guardianship. What happens to the children, maybe born of a particular brother or sister, a sibling, when that sibling passes on? How are the younger ones, the children, taken care of? There's also the issue of leadership and authority. We have already looked at the Shlubwana versus Nwamitwa case in the foregoing discussion. So all those are some of the issues that we really need to look at very closely. Last but not least, as a way of conclusion, we look at the fact and we reiterate that African customary law is an integral element of South Africa's legal system. It is no longer applied subject to the repugnancy clause, but it is applied subject to the Constitution. African communities enjoy the regulation of their private and public law relations in terms of the laws so close to their hearts, as opposed to foreign laws. And the African customary law continually evolves to meet the changing circumstances, because it is dynamic and not static. As a result, it is always able to address issues as they arise, but it must be chastised of those elements that cause it to be antithetical and at variance, if one could say, with the Constitution of the Republic of South Africa. Thank you very much for paying attention to this lecture. I hope it has actually enriched you. Remember to subscribe to my channel and to share the link with your friends, whoever may be interested in these issues, so that I can continually bring you more lectures on these important principles. Thank you.